Ladies and gentlemen. My name is Tori Cook, and I am Membership Director of the William F. Buckley Jr. Program here at Yale. It is my distinct pleasure to welcome you all to this afternoon's conversation with Professor Rick Garnett, entitled The Truths and Myths About Church, State, and the American Constitution. Before I introduce our guests, I'd like to say a few words about the Buckley Program. The William F. Buckley Jr. Program is the flagship program of the Buckley Institute, an organization dedicated to promoting intellectual diversity and open political discussion at Yale. We have hosted lectures, dinner seminars, firing line debates, and an annual conference every year since 2011. Our over 750 Buckley Fellows hold a wide range of political beliefs, but they all stand united against the formation of a liberal-only echo chamber on campus. By providing Yale students with a forum to engage meaningfully with serious conservative thought, the Buckley program has become an institution on Yale's campus and a symbol for more open and representative political atmosphere. Especially at a university where the mission is the cultivation and creation of new knowledge, Buckley Fellows believe that all perspectives must be heard and examined in good faith. You can learn more about the program and how to become a fellow at our website at buckleyinstitute.com. I also want to emphasize the Buckley program's commitment to freedom of speech. Disruption of an event is not consistent with Yale's policies on free expression as outlined in the Woodward Report. I would ask that each of you respect the right of our speakers to be heard and the right of your fellow audience members to listen to the event. Thank you for joining us in upholding the value of free speech. Now for our guest. Richard W. Garnett is Paul J. Schierl Fort Howard Corp Professor of Law, Concurrent Professor of Political Science, and the Director of Program on Church and State and Society at Notre Dame University. He teaches and writes in the areas of constitutional law, criminal law, the First Amendment, and law and religion. He is a leading authority on questions and debates regarding religious freedom and church-state relations, and is the founding director of the Notre Dame Law School's program on church, state, and society. Garnett clerked for the late Chief Justice of the United States, William H. Rehnquist, and also for the late Chief Judge of the United States Court of Appeals for the Eighth Circuit, Richard S. Arnold. He earned his JD from Yale Law School in 1995 and his BA summa cum laude from Duke University in 1990. He joined the faculty in 1999 after practicing law in Washington, D.C. with Miller, Cassidy, LaRocca, and Lewin. He is the author of numerous articles and has co-edited multiple volumes, including Religion and the American Constitutional Experiment, copies of which are on this chair. Please join me in welcoming Professor Garnett to the Buckley Institute and to Yale.
Thank you, Tim. Thank you for that. It's wonderful to be with you. It's great to be back at Yale. It always is. As you heard, I graduated from the law school here in '95, which was a real blessing. Going to Yale Law School opened up a lot of doors for me, and so much of the professional happiness I've had in the legal academy and as a legal scholar and as a lawyer is due to the formation and education that I got here at Yale. Even more important, on the first day of orientation back in 1992, I met the other Professor Garnett, who's my wife now of 31 years, so go New Haven. So my topic today is a little tricky. It's about two of the things that we're told never to talk about on airplanes or at Thanksgiving or in bars, and that's religion and politics. But I press on. I have 5 things I wanted to do. I've been told that you guys like a lot of Q&A, so I'll try to not wallow too much in professorial minutia. But 5 things I hope to do to kind of set up our conversation. My goal is to give you a sense of how I think about the American experiment in using law to protect religious freedom and to structure church-state relations. So the book, please take one. I promise I'm not making a lot of money off it. My co-author gets all of it, but I think it's pretty good. But we use the term the American experiment. And I want to tell you a bit about the details of that experiment. That experiment has a past, and it has a present. And part of that present is what the Supreme Court has to say about law and religion. So I'll be talking, because I'm a law professor, about some court stuff, but hopefully it won't be beyond the ability of non-lawyers to get. So here's the 5 things I want to do. First, just a few words about my first principles and my priors. You might think of them as biases, maybe that's fair, but let's call them priors, that sounds nicer. Second, I want to say just 3 quick things pulled from the book that I think are necessary to put the American experiment and the court's work in context. Third thing I want to do is give you a super duper quick overview of the Supreme Court's doctrines having to do with religious freedom and church-state relations. I teach a course that's a year long on this topic, a full year. You guys are going to get it in like 10 minutes, so what a bargain. The fourth thing I want to talk about is what I see as some challenges to the American experiment in church-state relations. And then, if we have time, a few concluding thoughts. So, to start, some priors. I see religious freedom correctly understood, and sometimes it's incorrectly understood, but religious freedom correctly understood as a fundamental and foundational human right. Right? It doesn't matter because the Constitution protects it. Rather, the Constitution protects religious freedom because it matters. We shouldn't think of religious freedom as a concession by or a gift from the government. The correct way to see religious freedom is as a structural limitation on the claims and authorities of government. Right? Every person, because he or she is a person, has this foundational human right to religious freedom. It's not merely a matter of toleration by the majority. It's a right, that is, the right to freely exercise one's religion, is a right that everyone enjoys. In my view, everybody has a stake in the health and well-being of the religious freedom experiment. This is true whether you're a religious believer or not. Right? As I see it, a political community that respects religious freedom is going to be one that respects other freedoms as well. And conversely, a state that is unwilling to respect religious freedom, a political authority that is unwilling to recognize any limits on its own claims, is one that's not likely to respect other rights. Right? Rights that even if you're a non-believer, you might think are pretty important. Rights to speech and association and privacy and property. Right? The fact that religious freedom is foundational because a political community that respects it is making, if you think about it, a really generous and yet bold claim, namely that there are things that are not Caesar's. There are things beyond the authority of government. And at least in my view, a political community that is willing to recognize limits on its claims is one that, all things being equal, I prefer. Now, the task of protecting religious freedom through law is not easy. It's complicated. Religious freedom claims can't be absolute. Right? There are claims that the common good has, claims that the political community has. There are going to be trade-offs. There will be tragic cases. But my view is that, generally speaking, the American experiment has been and continues to be a success. Right? This isn't to say that all things about it are perfect, but it's worth remembering whenever we read about challenges to religious freedom in the newspaper, that we in the United States have been pretty blessed, because usually our fights are about things like, can you have the 10 Commandments in the courtroom, or do you get an exemption from a law against peyote if you belong to a Native American church that wants to use it in a sacrament, or if you're a Muslim prisoner in a jail and you want to grow a beard, do you have a right to do that? These are important questions for sure, but it's worth remembering as Americans that in a lot of places around the world, people are desperate to be fighting about that stuff. Right? Instead, what they're trying to deal with is having everybody rounded up and put into concentration camps, or having their churches bulldozed over, and so on. James Madison once said, and you can always, as a law professor, you can always kind of get away with saying James Madison once said. It might be true. Who knows? This guy Tocqueville, right? When you hear something smart, you forget who said it, say Tocqueville said it. It works out fine. Anyway, James Madison once said that America's experiment in religious freedom, which again was a matter of right, not a matter of toleration. He knew about toleration. They'd achieved that a century before. He went further. But that America's experiment in the right to religious freedom would add, in his words, luster to our country. And I think he was right. That's point one. Here's the second thing I want to do. 3 big framing points. Again, you can learn more about this in the book, free, to help you situate America's experiment. The first point I want to make is that the American experiment is older than Thomas Jefferson and James Madison. A lot of times in the narratives we hear about religious freedom, about church-state separation, they're very myopic and focused. Now, don't get me wrong, I'm kind of an originalist. I clerked for Bill Rehnquist. I like the founding a lot. But the history of the American experiment is older. To really understand how some of these ideas like freedom of conscience and the distinction between church and state, how those ideas developed, you got to go back further. I suggest it goes back to, a sermon where someone said, give to God what is God and Caesar's what is Caesar's. But even if you're not with me on that, there are centuries of contestation between emperors and popes and kings and bishops, right? Think of the murder in the cathedral or the drama of Henry and St. Thomas More through the Reformation and on, right? It's worth remembering that our founding generation didn't just pluck the idea of religious freedom from out of the ether, right? They were at the tail end, as they saw it, of a long history where religion and politics had been contesting to try to decide what the proper sphere, regulatory sphere of authority was between the two. And sometimes religious authorities were on top and sometimes on the bottom. But our founding generation was aware that this fight had been going on for a long time. And so when we think about ideas like the separation between church and state, they weren't thinking like we sometimes do today, like, oh my gosh, what if the president says God bless America on TV? That's not the issue. What they were thinking about is, should the king get to pick the bishop or not? Right? Debates about questions like that are part of the roots of the American experiment, even if today we don't see those kind of debates very much in America. The second historical point, this is about the American founding. It's worth remembering that even in our own founding, it wasn't just the Virginians. We often focus only on them. Madison's famous memorial and remonstrance, Thomas Jefferson's famous letter to the Danbury Baptists. But there were a lot of different voices, even at our founding. Voices of like dissenting evangelicals and Baptists. Voices coming out of the Congregationalist and Puritan tradition. Voices that in our book we call civic Republicans. People like George Washington who, even if they weren't quite so sure where their religious beliefs were, they thought that religion was going to be essential to forming the kinds of citizens that the new republic needed. And then, of course, there were more of these kind of Enlightenment deist types, maybe in the tradition of Locke and others, who Thomas Jefferson represented. But the point I want to leave you with is that all of these voices were a part of the discussion about what the American church-state arrangement should be. And then, third, sometimes in law schools and in courtrooms, there's an effort to reduce the American experiment in religious freedom to a single principle, one ring to rule them all. Sometimes it's separation. Sometimes it's neutrality. Sometimes it's conscience. And a key point to appreciate, I think, is that there were a lot of principles that all went into this experiment, and that our law, when we're doing it right, involves an effort to strike a balance among these principles. So the freedom of conscience is one, right? The freedom to believe what you want about religious matters. But not just conscience. The free exercise of religion. That is, the freedom to practice your religion, to act, to take your faith out of the church hall on a Saturday, right? And to take it out into the public life. The principle of religious pluralism, the principle of religious equality, right? From the beginning, we often look back on the founding and think, oh, it was homogenous. Everybody was just a Protestant Christian. It seemed really diverse to them at the time. So there was a healthy appreciation, even in the misty 1700s, of religious pluralism as a fact of life, and of religious equality as something that the law should protect. We embraced disestablishment of religion, right? We decided that religion and religious freedom would flourish best if it was disconnected from official ties to political authority. And then that takes me to the sort of final principle that I think is part of the discussion, which is the separation of church and state. That separation is often misunderstood. I think it's fair to say that people on, for lack of a better word, my side, the more conservative side of these debates, are particularly likely to misunderstand it. We should not think of church-state separation as meaning religion is absent from public life, or that there's a naked public square, in Father Newhouse's famous words. What I'd like you to think about, we can develop this more in Q&A if you want, is that the separation of church and state, correctly understood, involves this crucial distinction between religious and political authority. Correctly understood, the separation of church and state is a protection for the church from the state, and it needs to be seen in that light. Okay, so I've done 1, 2. Now let's talk about the stuff the Supreme Court does. I think you can lump all of American church-state law, at least as the Supreme Court sees it, into 4 categories of cases. I'll tell you the 4 categories. I'll give you an example. Maybe this is kind of cheesy. I apologize in advance. I tried to make the categories kind of rhyme. But there's cooperation, accommodation, expression, not quite a very good rhyme, and differentiation. Okay? Cooperation, accommodation, expression, and differentiation. What do I mean? As I go through these 4 categories, with respect to each one, I want you to be thinking, there's a way that a misunderstood version of church-state separation could get this category wrong, and there's a way that a correct understanding of church-state separation can help us to get it right. So the first category, cooperation. These are cases in America that are mainly about, guess what, money. A lot of them have involved schools. A lot of you are probably familiar with debates about school vouchers, school choice. Think about things like student loans going to religiously affiliated schools, something my students at Notre Dame are big fans of, right? Medicare goes to Catholic hospitals and Lutheran hospitals and so on. Here's the point. In our tradition, government and religion often cooperate in order to try to accomplish public goods, feeding the poor, clothing the naked, right? Resettling refugees, educating people, providing health care. In America, it has never been the case, adoption, that those jobs only belong to government. It has always been the case that even though those things are important for the public good, they're not distinctly religious things, they're not just worship, that government has felt like it was totally fine to cooperate with religious institutions, right? Particularly in the educational context, which is the context that I pay the most attention to. So for a time in the 40s, 50s, 60s, 70s, some bad things happened. Like bad carpet colors, bad design, some good music, but a lot of bad stuff. One of the bad things that happened in the 70s was an understanding of church-state separation that led people to think it's a violation of the separation of church and state if kids are allowed to take scholarships to go to parochial schools. If it's a violation of church-state separation if the government provides grants to low-income families for school lunches that they use at parochial schools. Right? There are lots of cases in the Supreme Court about these kinds of things. Where's the line? At what point does cooperation cross over into being an establishment? About 20 years ago, the Supreme Court cleaned things up quite a bit. And in recent years, it's been doing even more of it. And as you might have heard, there's a big case coming up this year that touches on this issue about a Catholic charter school in Oklahoma that I'd be happy to talk with you about. I'm actually involved in it, so I'm going to be biased, but I'll still be correct. But the point here is that this first category of cases, cooperation, I want you to see that if we understand separation correctly, this doesn't mean rejecting church-state separation, understanding it correctly, that permits reasonable cooperation between religious and political institutions in order to accomplish the common good. Second category, accommodation. Accommodation usually involves situations where religious believers want to have an exemption from a law that would otherwise apply. Okay? So one of the most famous cases involved some Amish parents who wanted to take their kids out of school after 8th grade. Wisconsin law said you had to go to 10th grade. They said, we want an exemption. Accommodate us. Give us a break. Make it easier for us to practice our religion. We know we're not the majority, but help us out. Another famous case involved some members of the Native American church who used peyote as their sacrament, as part of their sacrament. Peyote was illegal at the time. Still is in some places. They said, look, we get it. Peyote's illegal. Don't prosecute us. Give us an exemption. So a lot of times in American law, in order to accommodate religion, in order to make it possible for people to exercise their religion, you have to give someone an exception. Now this is controversial, often, because your instinct, I hope, is to think that, you know what, everybody should follow the law. The rule of law matters. Democracy matters. If the majority passes a law, everybody has to live by it. If you don't like it, either move or politically agitate. And generally speaking, that's how we do things for most topics. But in America, from the very beginning, right, debates about the Quakers and military service, for example, from the very beginning, we've thought that it was appropriate to accommodate, sometimes, religious objectors by giving them exemptions from generally applicable laws. Okay? And so again, today we've had examples of this in the news, some of them quite controversial, right? There's a vaccine requirement. Somebody objects for religious reasons. Should that person get an exemption? There's a rule that says every employer has to provide cost-free provision of birth control medications that some people believe cause abortions. Should those employers get an exemption? Lots of different controversies in this area. We can talk about them in detail if you want. But here's my suggestion to you. Once again, if we understand separation correctly, it's consistent with accommodation. It's okay for the government, even a secular government, to take steps to make it easier for religious believers to live out their faith. Now remember, accommodation never comes up if everyone agrees and the government doesn't do much. When people disagree and the government does a lot, you're going to have more room for conflict. We have a pluralistic society. We have a welfare state. So we're going to have conflicts. Accommodation is one way to navigate those conflicts. And in my view, it's consistent with separation correctly understood. The third category, recognitions, T-I-O-N, I know it's cheesy. A lot of these cases have involved situations where there's religious symbols in public, right? Religious art on the wall of a national museum, a menorah during Hanukkah time in front of a town hall, right? A Christmas tree in the courthouse, the Ten Commandments in the courthouse. If you're following the news, the Ten Commandments in public schools in Texas and Louisiana, right? Presidents all the time saying, "God bless America," issuing Thanksgiving proclamations. Christmas is a federal holiday. There's Jesus on the stamp at Christmas time. And we have a town called San Bernardino, right? Lots and lots of public acknowledgments of religion, lots of symbology, lots of expression. Most famously recently, a public school football coach who decides at the end of the game he wants to go kneel down at halftime and say a prayer when everyone can see him. What about these cases? So for a time, the thinking was, if you have religious expression in public, that violates church-state separation because religion is supposed to be a private matter. And the concern was, if the government's involved in these symbols, right, if the government puts up a Christmas tree or if the government puts up a creche or something, that the government is in effect endorsing religion, and if the government endorses religion, that means it's establishing it, and that means it's violating the separation of church and state. This is of the four areas I'm talking about, this is the most complicated area of law, but here's my view. I don't think that church-state separation, correctly understood, forbids the government from acknowledging and even participating in expression about religion and about the religious beliefs and traditions and heritage of our people, right? They can be diverse, right? But they can still be religious. So I worked on a case one time in New Jersey where the city of New Jersey had a practice of putting up religious symbols in its main, the city of Jersey City, sorry, putting up religious symbols in its town square all the time. You know, there'd be something for Diwali, something for Hanukkah, something for Christmas, and on and on and on. This was challenged as a violation of the separation of church and state because the government was putting up religious symbols. And the court, correctly in my view, they were correct because they adopted my position, my client's position, they said, look, if you step back, what's going on here is the government is recognizing, there's that word, recognizing certain facts about its population, including religious facts about that population, and that's fine. It doesn't violate the separation of church and state. And then here's the final category. All right, we've had accommodation, cooperation, recognition. I call this differentiation. These are cases that involve the distinction between religious institutions and political ones. They usually involve the right of religious institutions to govern themselves. Some of these cases recently have involved disputes about religious schools wanting to hire their own teachers, right? And teachers have said, well, you know, you didn't hire me, you violated a discrimination law, and so they sued the school. So I think most of us would say Walmart shouldn't be able to fire somebody for being Baptist. But I would say, on the principle of differentiation, a Catholic school can fire someone for being a Baptist. Some of these cases get kind of controversial because you have to figure out what counts as a religious institution, right? Does a soup kitchen count? Or what if there's a big hotel chain that's owned by a religious denomination? Does that count? The lines aren't always easy. But I think schools are pretty clearly on one side of the line. So in my view, and this is in a way, this is the category of cases that is closest to the historical issue about church-state separation. It's really important to keep in mind that even though religion can participate in public, even though citizens are allowed to bring their religion with them into the public square, even though government and religion can cooperate in order to pursue the common good, there still is this difference. There still are things that are not Caesar's. We don't want our government coming up with a King James Bible, right? Although President Trump apparently tried to come up with a Bible, but let's put that aside. And we don't want, we don't want the Secretary of State picking the bishops, and we don't want the bishops setting the speed limit. That's what differentiation means, and that's consistent with church-state separation, correctly understood. Okay, I'm going to wrap up pretty quick because I'd like to have Q&A, but I'm just going to quickly say, I know I said I would do 5 things. This is 4. I'll stop at 4. I just want to identify a few challenges to the American experiment that I think are out there, and you've probably experienced some of them in your own discussions. The first one is this phenomenon. It's sometimes called the rise of the nuns, the N-O-N-E-S, not the other kind. My daughter is in training to become a religious sister, and she gets a real kick out of that joke, although she's really tired of it now. But the rise of the nuns, people who in surveys say, I have no religious affiliation. This has been increasing in America. What do we make of that? Now, some experts would say it's not really, what's really going on is just people who were never religious are starting to tell the truth about it. It's not really a big change in our society. Nonetheless, it does appear that institutional religion is on the wane, that fewer people are connected to religious institutions and traditions. Why do I say this is a challenge? I do worry that our experiment in religious freedom, because it so often does involve kind of institutional contestation, I worry that it's weakened if we're all kind of on our own, right? It seems to me that human beings are social creatures. Human beings need to be embedded in communities and associations and groups and traditions. If we're just on our own with our own personal spirituality, it's harder to stand up against the state. That's a concern I have. The second challenge is related. If we become, as some people say we are, less religious, does that mean that religious freedom starts to be seen as kind of a luxury good or a quirk, right? Like, do religious believers and their claims start to be regarded as people who have, really weird hobbies like train spotting or something like that, right? There's a risk that religious freedom is more vulnerable if not everybody thinks they have a stake in it anymore, right? Now, I try to make the argument that even if you're not a believer, you have a stake in religious freedom. I talked about this a little earlier. But I do think it's a challenge that if religious freedom becomes regarded as a luxury good, it's easier for government to kind of say that other things outweigh it. And that's dangerous in law, it seems to me. Third problem, also related, is about political polarization. I think it is unhealthy for our legal experiment in religious freedom if the religious freedom cause becomes identified with one side of our very divisive politics. It should not be seen that way. I work on a lot of religious freedom claims that involve claimants who political progressives would find very sympathetic, and then also some that political conservatives might find more sympathetic. My view is it shouldn't make a difference whether you sympathize with the person's beliefs or not, right? If it's a Catholic doctor who doesn't want to participate in an abortion, or, on the other hand, this is at Notre Dame, we're representing a Native American tribe that's trying to prevent their sacred land from being strip mined. You might think those have different political valences, but for religious freedom purposes, it shouldn't matter. But I do worry that it does matter. Surveys suggest that of our 2 political parties at present, one of them is more likely to say they care about religious freedom than the other, and I think that's a mistake. And then here's the final challenge. This is a little bit, this isn't so much empirical as it is kind of terminological. It's this word secular. I think sometimes religious believers sort of recoil from secular because they think it means anti-religious, and sometimes it's used that way. But historically, that's not what it meant. It's just there's the seculum, that's the here and now, this life, and then there's the next life. But secular didn't mean religion-free. Again, it didn't mean a naked public square. But I do encounter, at least in the law business, often the suggestion that because our government is secular, it follows that we can't have cooperation, we can't have accommodation, we can't have differentiation, and so on. I think that's a mistake. I think it's perfectly consistent to say religious freedom really matters and the government should care about it, and the government should accommodate religious believers. That doesn't make the government not secular, right? What would make the government not secular is if the king started picking the bishops. So, just to wrap up, and then I'll take Q&A, and if you don't have any Q&A, then I can keep talking more and more. I want to be clear about my takeaway. It's wise to distinguish or to separate religious and political authority. That's what the separation of church and state means. That's what it meant to the founding generation. That's what it should mean today, right? We don't want kings and emperors picking our worship services or our liturgies. But it's a mistake to take that insight and then start taking this image of a wall of separation and plopping it down everywhere where it doesn't belong, and suggesting to religious believers that they have some kind of an obligation to disintegrate their lives and to keep their religious faith tucked away or to keep it private, to not make religious arguments, to not draw on their religious beliefs and morality when they're making political claims, right? So, in our situation, again, we have separation not to put religion behind a wall. Rather, separation protects, when it's correctly understood, the freedom to build and to live an integrated and balanced life. Or that's my pitch anyway. So that's all I've got for now. And if there's free books and there's cookies, and if anybody has questions, I'm happy to do my best.
Okay, I'm going to start us off with a question, and then we'll turn it over to audience Q&A. Professor, you mentioned how at the time when these protections were being put in place, the society at the time considered itself very religiously pluralistic. They saw a difference here. We are now much more so religiously pluralistic. My question is whether we are too, or if there's a point in the future which we might become too religiously pluralistic for the protections that we have in place to stand. And I'll kind of point to one phenomenon that I'm hearing more about is this so-called rise of the secular religion, which, with the point you were making, a connection to the government being secular, can start to perhaps blur ties there, whether you think that this has an impact on the way that religion's freedom will be protected in this country or can be protected legally, and kind of the considerations and concerns that you see there.
Yeah, this is a huge question. So I probably used the word religion or religious just in the last 35 minutes like 10 million times, right? But I never defined it. And interestingly, the Constitution doesn't define it. And there's disagreement. Some of you probably, like divinity students or religious studies students, you know that among the experts and the scholars, there's disagreement about what this category even is. And yet, we have it in our Constitution. It's in our constitutional text. We have to use it. The Supreme Court hasn't bothered defining it. Thanks a lot, Supreme Court. But we have to muddle through. So to your point, one thing that I've written about some and some others have as well is that in order to protect religious freedom, the government doesn't necessarily have to settle on a sort of precise black and white definition, but it can't let religion include everything. There's got to be some limit to what counts. And the court has said this in several cases, right? And this is an interesting contrast with some European jurisdictions and international human rights law. If any of you are familiar with that, in a lot of other jurisdictions, they'll say, rather than saying freedom of religion, they'll say freedom of conscience or belief. And that's intentional. It's designed to protect secular commitments in the same way as religious commitments. That's not what our Constitution did. Some states have done that, some statutes have done that, but in the Constitution, it was clear that it was religious conscience that was specially protected because religion was seen as involving duties to God that were higher than duties to the state. So the idea wasn't that religion is a stand-in for anything someone happens to care about, right? So this is tricky because if everything counts as a religion, you can't give everybody accommodation and exemptions, right? The government's got to run, right? It can't be that any time someone objects to X, the government gives them an exception to X. We might treat religion specially, and some people think that's controversial that we do, but again, in our system we do. Now you asked, what if we get sort of too diverse? I guess my view is that that's not a problem. As long as we keep our eye on the ball and say what we're doing is protecting religious freedom, I think we can recognize that there are all kinds of forms of religious expression and religious communities and religious traditions. But of course, religious freedom is not absolute in our tradition. Claimants don't always win. I didn't go into all the legal doctrine buzzwords, but in the cases, even if someone sincerely asserts a religious request for an accommodation, sometimes they lose if the government has a compelling interest that overrides it. And that's the way I think it has to be, right? So I think we can be pretty generous and capacious in terms of recognizing lots of different religions, as long as we're kind of clear-eyed about the fact that, the claimant's not always going to win. Yes, sir.
Hi, I'm Nico. First of all, thank you so much. This has been fabulous to listen in. You talked about the ability of a king to pick a bishop. I'm curious about the inverse and the sort of ability of the state to regulate undue sort of pressure from a religious organization. One of the things that we think about is sort of the rise of the evangelical Christian movement as having sort of a political purpose that is able to potentially, get representatives that align with a religious affiliation in a particular. So in that sort of inverse of a bishop is picking a king, or on a more regional level, neighborhoods in New Jersey where there's significant Muslim populations being able to sort of use religious context as a way of taking over mechanisms of the state. What is the sort of rationalization of being able to draw a distinction there, and what mechanisms are there for pushing back on that instance?
So there's at least two layers to this, and this can get really complex, as it sounds like you know. In my view, it's not the king picking the bishop, like Henry VIII picking the Archbishop of Canterbury or whatever after he took all the churches, abbeys, and money and all that good stuff. Not good stuff, bad stuff, but that's not analogous to democratic politics, where religious believers who have shared interests and shared concerns, coalesce around shared goals and participate in democratic politics and get their will. So as I see it, it would be unjustified for the government to ever suggest that religious believers or institutions for that matter, are somehow kind of disabled from engaging in regular democratic politics. Interest groups in our system are always going to exist. There's always going to be parties. There's always going to be, again, shared identities, and they're allowed to try to, make the process work for them, so long as the outputs of government are consistent with the limits on government power, the Bill of Rights, right? So, in my view, anyway, it's appropriately the rule that the political authority doesn't set religious doctrine, doesn't pick bishops, doesn't tell a Catholic school who to hire, doesn't tell anybody what's kosher and what's not, right? The political authority doesn't have authority over those kinds of questions. The analogy to that is, we shouldn't have a House of Lords type arrangement where the Cardinal Archbishop of DC gets to sit in the Senate, right? Or wherever. But I distinguish that debate about the relationship of authorities from, on the other hand, just religious believers participating as integrated citizens living out their beliefs the same ways everybody else can in politics. Does that mean that sometimes you're going to have homogenous communities where, let's say 80% of the people belong to a particular religious tradition? Is the law going to reflect the views of that 80%? Probably. Just like in some other community where it's 80% secular, it might go that way. We have a Bill of Rights to take some things off the table of democratic politics, appropriately in my view. But I think we shouldn't understand church-state separation as requiring citizens to sort of censor or check or remove themselves from public life, again, when they're participating on equal terms in democratic politics. Yes, sir.
Thank you very much. Thank Be better, yes? Not in this room, but on the camera. So my question is related to Alexis de Tocqueville in his Democracy in America. Begins
Really, de Tocqueville, or are you just pretending? No.
yes, exactly. It's related to, you know, the start of the work is sort of this outline of the history of American ideas in a sense, and his thesis mainly is that religious freedom emerged from the, you know, Puritan New England, that their sort of stance on religion was that we will have a very strong religious-oriented society, but we recognize that we're fleeing a society where, you know, we were persecuted from our religion, and so what we want to instill is these sorts of, you know, religious values without actual, you know, particular religious dogmas being the law of the land. So where do you think this sort of Puritan idea of religion in America, how it intersects with the Jeffersonian Enlightenment idea of America? I would just love to hear more about your thoughts that you talked about earlier, where, you know, the idea of separation of church and state goes back farther than just Jefferson. Where does that come from?
Yeah, and goes, well, thank you. It goes back, you know, big Tocqueville fan here, and I like it. I've always liked it. I'm sure he's relieved to hear that. That in that work, he did call our attention to the fact that, you know, the Puritan intellectual influence hadn't been somehow like overshadowed completely by the Virginians. In the book, plug, the image we use, you know those little tents that you pop up at tailgates or kids' soccer games, you know, like they're four corners, right? And so we called it a canopy. And the idea was there was sort of four corners of the canopy, four kind of distinct traditions, but cooperating, working together, mutually supporting each other, that kind of held up the American experiment, the canopy. One is this kind of Enlightenment tradition, right? John Locke and so on. You see that most, I think, obviously in someone like Jefferson or Madison and so on. Another tradition was precisely this kind of Puritan tradition that was older, that had been in New England, where people, on the one hand, they were fleeing one form of persecution, on the other, they kind of imposed another sometimes. But they did have a sense, unlike maybe Jefferson and some of his friends, they didn't think religion was going away, and they thought it was important for citizenship, and they thought that cooperation between the city of God and the city of man was appropriate, right? That's a part of our conversation. A third corner, I mentioned the civic Republicans, right? People who were kind of fixated not so much on theological truth, but on the role of religion in inculcating the kinds of virtues that they thought a democratic republic needed. And then the fourth were people we call evangelicals, but these were often like, they were Baptists and Methodists who were dissenters from the Congregationalist establishment in the North or the Church of England establishment in the South, right? I actually have a distant relative, you know, 5 greats or something, who was a Baptist minister in Virginia who was imprisoned for preaching without a license. And there's actually a letter where James Madison is writing to James Monroe, I believe, to complain about how my ancestor was being locked up. He was one of these dissenting Baptists who was preaching without a license, right? That's a very strong claim about church-state separation. The government can't license preaching, and that came out of this fourth group of evangelicals. So they're all part of it. I'm sure Tocqueville would agree, but I guess this is a really long-winded way of saying, you're right, that was an important point he made. Yes, ma'am.
Yeah, I'm really interested in what you said about the rise of the atheists in America, and I'm curious your take on just the relationship between religion and society. If you think the main reason for moral decline in America is because of more people being non-religious.
So I want to distinguish between two things. One is let's sort of define atheists as people who have kind of a firm, committed belief that there is in fact no God. Okay, I meant to mention a different category of people, the rise of the nuns. These aren't people who don't believe necessarily in spiritual things. A lot of times the same people who say, I'm not affiliated, I don't go to church, I don't belong to a tradition, and they say, how often do you pray? Oh, every day. You know, so you have a lot of people who are spiritual but not religious. I don't think of those people as being quote unquote atheists in the way that like, you know, Dawkins was in his book, you know, or you know, Hitchens, right, those guys. So it's not obvious to me that in the United States, the number of like atheists, you know, precisely defined is all that big. I don't know for sure. I think there's just dispute about this. My point is that even if we're talking about people who are spiritual but not religious, and you know, good people all, or most, but that could be risky. Even if they're still kind of believing in something, it could be risky for religious freedom if they're totally disaffiliated from communities. I have kind of a communitarian sense that it's kind of another Tocqueville type point, but that if you really want to be able to resist political authority when it's appropriate, you need those little platoons. You can't have people standing by themselves. Now, your second point is about the relationship between unbelief and kind of moral standards and so on. And I have to admit, I have mixed feelings on this. I mean, on the one hand, I have some kind of philosophical commitments that make me think that unless there's a God, a lot of our talk about moral standards is kind of constructed and all that. But let's put that aside. I don't think history suggests that being religious guarantees that one will behave well or behave decently or behave charitably. And I'm sure history suggests that there are lots of people who don't have religious belief who behave decently, charitably, and well. And I wouldn't want to make the case for religion or for religious freedom depend too much on a claim that religious believers are more likely to behave well, right? I wish we did, but in my view, the argument doesn't depend on that. Yes, sir.
Thank you so much. This has been really a great talk. I had a question about like laws more generally. Aquinas says that laws are the rational ordering of things. And it seems like you pointed out that if a state has fewer people who believe something, they're less likely to protect that thing. That seems like a subjective ordering of things based on not some rational moral principle, but instead the whims of the people. What is your belief? Should laws be based on the rational ordering of things or the subjective views of the people at a given time? And what is the view of the state currently? Why do you think they would pick more of a subjective approach versus a fundamental approach based on morality?
Yeah, so it sounds like you know a lot about this. The classic definition that St. Thomas gave of law was an ordinance of reason promulgated by one who has authority and directed to the common good. I think it's tough to improve on that myself. Think of the different parts, right? Promulgated means it's put out there. So laws aren't whims. They're stuff that are put out there so that people know what they are, they're on notice, they can follow them. It's an ordinance of reason, not just mere will or preference, right? Ordered to the common good, so not just to kind of private advantage or the will of the stronger, right? And then by one in authority. There's this idea that, you know, law emanates from authority. So, you know, when a bandit comes up to you, this is an example St. Thomas gives actually, a bandit comes up to you and tries to take your money and demands it, he's not enacting legislation, right? He's doing something else. So law is supposed to be different from threats, from robbery, from mere subjective preference, from merely the will of the stronger. It's supposed to be more, an ordinance of reason, promulgated by one in authority for the good of the community. That works well for me, right? Now, here's the rub, right? At least these days, people disagree about what the most reasonable and prudent way to accomplish the common good might be. And so I'm kind of a fan of, you know, small L liberal constitutional democracy, which tends to structure decision making in such a way, doesn't guarantee the right outcomes, but it structures decision making in such a way that, you know, this side of heaven, we hope we're going to get results that approximate good laws that promote the common good more often than not. It seems to me, and I think this is consistent with Aquinas, that it is part of the common good, correctly understood, that there be rules in place that respect the religious impulse and that protect religious freedom. Right? So it turns out, and you know, he wrote some pretty big books, right? Taking some big books and shrinking them a whole lot, that in my view, the workings of reason aiming at the common good, so not necessarily making theological claims about, heaven and hell and death and judgment. Ordinances of reason about the common good provide us with, I'm repeating myself, but they provide us with reasons for having legal protections for religious freedom in place. Yes, sir.
Thank you very much for your talk. I was curious if you believe that organizations that are similar to religious institutions in their drive to inculcate morals and ethical values, but perhaps do so without directly invoking the name of God, for example, scouting organizations, philanthropical organizations, should these enjoy the same level of access to things like accommodation and differentiation that religious organizations do?
Yeah. So we have in American constitutional law a body of cases and doctrines that sometimes travel under the name of the freedom of association or the freedom of expressive association. And I've written about this, and they kind of reflect, again, this Tocquevillian sense that it's a good thing for a political community to have a healthy civil society. That political communities are weak when there's nothing between the individual and the state. Sounds like you know all this stuff, right? That political communities are often unstable when they sweep away all the intermediate associations. This was a problem, for example, I think with Iraq after the Gulf War. So I'm a big fan of the freedom of expressive association. So I think the Boy Scouts do enjoy First Amendment rights to select to a great extent, right, their own leaders. I think it's really important to have a healthy nonprofit sector. So like, it would be bad if we constructed our corporate law in such a way that it didn't make it possible and indeed easy for nonprofits to operate and so on. But I'm gonna say not as much. There's a whole lot of good things to be said about civil society, freedom of association, social ontology is kind of the buzzword. But I do think the religious freedom claim goes a bit further because it's making a claim fundamentally about an obligation that is higher than the obligation to the state. And I don't think that's really what's going on with the Boy Scouts and the Red Cross and that kind of stuff. So I don't see it as an either or, but your question is really important because in my business, I often encounter arguments from people who are skeptical about religious freedom, and they'll say, look, it's enough if we just say that churches are like the Boy Scouts. I wrote an article once, are churches like the Boy Scouts, ? No, but even though they operate it. But you'll sometimes encounter this argument that that's enough protection for churches. And it's not bad. I mean, it's pretty good if you can get it. But I would want to say that religious freedom rests on sort of foundations that go a little deeper, right? And it's the claim that it makes is in a way a little more radical. But I don't want to get rid of a variegated social ontology either. Yeah. Sure, go ahead.
Hi, I'm Serena. Thank you for your talk. So you talk about how the rise of the nuns is dangerous politically for churches and also American people in general. Do you think that public education, which has more of a secular, even atheist leaning, have contributed to the rise of nuns? And if so, what's the solution?
Yeah, I want to step back a little bit from the word dangerous, just because that might sound a little too alarmist for the TV. But I do think it's a challenge to the religious freedom experiment if we have increasing levels of disaffiliation. That's the claim I meant to make. Have the state-run school, I have kind of a bugaboo. In my view, public schools means schools that educate the public, which includes a lot of schools besides the one that the government runs. So let's just focus on the schools that are state-run. For a lot of American history, state-run education was thoroughly imbued with kind of appreciation for religious belief and religious traditions and all these kinds of things. And then we get decisions in the 60s that outlawed school prayer, outlawed Bible reading. I happen to think those decisions were correct. But I do think that in our state-run schools, in some parts of the country anyway, we've we've gone too far in the sense that we understood church-state separation as requiring the total evacuation of religion from public education, where kids are spending 12 years, 8 hours a day. In my view, it's consistent with public education, it's consistent with neutrality, it's consistent with separation, for kids to learn about things like world religions and the role that religious belief has played in a lot of American social movements. I mean, how on earth would you understand the civil rights movement or the abolitionist movement or the very unfortunate prohibition movement if you didn't understand the role that religious believers played in that? I tend to come down on the side that I don't want the government schools to do what I want my parochial schools to do. So I wouldn't, but even there, I think public schools could have, this is a debate right now, could have release time where kids could leave for an hour to do their CCD. That's what I did when I went to public school. And that's gonna happen in some places. But the actual catechesis and evangelization and religious formation, in my view, should be done by the church, by the family, not by the state. That's what separation means. But it doesn't mean that the public schools have to be anti-religious. And it doesn't mean things like when little Junior comes in to do his book report on St. John Bosco, the teacher tells him to sit down because you can't talk about St. John Bosco in a public school. That's not right.
Thank you so much, Professor.
Thank you guys for coming. Yeah.
If you could all join me in thanking the professor one more time.